Hey everybody, welcome to the Bold Today Show. I'm your host, JD Hoovener, managing partner and owner here at Bold Patents Law Firm. Because I want to take at least 10 minutes or so and kind of dive into GUIs and what's patentable, what has been done already, and kind of the history there, which is kind of fascinating. All right, so let's get to our subject, graphical user interfaces. I want to talk about graphical user interfaces and kind of what they are and whether they're patentable. So let me show you a little bit. I found a great article on it. I'll share my screen with you. Some of the first graphical user interfaces were put up by Xerox. The Xerox Star back in 1973. The Apple Lisa in the 80s, Macintosh, and of course Windows, and eventually the iPhone, which is very famously well known for their design patents on the way that the phone itself looks. A graphical user interface is really just that. It is a digital representation of the way something looks. Okay, and so on the right is sort of a perfect example of that, right? You've got this, if you've got an iPhone, this is kind of one of the first adaptations of it, where you've got these icons that make up different applications, right? Apps. And that the way that they're laid out, the way they appear on the screen, that is patented under a design patent, right? You see that D right in front of the numbers. That designates a design patent. So they're getting protection on just the way that it looks. And infringement is found based on an ordinary observer, right? Someone who buys a phone or an ordinary observer of this type of industry, would the infringer, the infringed product, does it seem like it is substantially the same as what is covered under the design patent? That's the question. Right, this very objective, simple test that a judge and jury would have to answer. So it does provide pretty decent protection, and it's what eventually caused, in the gigantic case of Apple versus Samsung, Samsung to settle with Apple based on their design patent and how similar they were. But I want to go to Google and show you a couple examples of graphical user interfaces, and also I love using the Google patent search tool, so I want to show this as often as I can. I just simply typed in graphical user interface, right, as my keyword. I came down here under type and hit design patent. And then I want to look at those that are just grant, already actually have the right to grant. So you got to select design and grant. So let's look at this first one here, just to kind of dive in to understand what it is. You don't have to be the first one to come up with something as groundbreaking as Apple's iPhone, right? Here's an example of a design patent that was granted just a couple of years ago in 2018. Display screen portion having graphical user interface with transitional icons. And that's a great point, actually, because I found that it's not just a static image, okay? You can get protection for a moving image, right? Something that actually moves over time. You can see they've got these sort of rings, right? Sort of concentric rings, and they're moving, right? I think this could be some sort of a timer or a delay. I'm not sure what the functionality is, but remember, with design patents, we don't care. The U.S. Patent Office doesn't care what these rings actually do, right? What they signify, whether it's like a retina scan or a fingerprint. It's just what they look like. And so the orientation and the movement of these circles is protected under this design patent. So this, if you see any other symbols or icons on a smartphone like this, and it's not owned by this patent, you're likely infringing Snap Inc. Their patent here. So much like utility patents, you will see on the left side some more detail about what the history is. So you can see that this was filed in 2015, which means any inventor that came after that loses to a priority battle. I mean, if someone else had filed this similar or almost the same exact invention, in September 2015, they would have lost in a priority battle to this patent. Design patents are good for 15 years after the date of issue, whereas utility patents are 20 years from the date of priority. You can see the patent documents and the prior art. So a lot of these are related or similar. This is what the patent examiner cited as, hey, I at least found these, and these are sort of similar. Or there are also references that the inventor had to come up with and tell the patent office, hey, look, I found these on my own. These are similar, but here's how mine's different. And the claim, right, the actual what the inventor owns here, what the assignee owns, Snap, is the ornamental design for a display screen portion having a graphical user interface with a transitional icon as shown and described. And hopefully people understand what the graphical user interfaces are now, and you're able to kind of appreciate that. I do want to make sure this book gets out there during the session. I wrote this book, Bold Ideas, The Inventor's Guide to Patents, a few years ago. This is still very, very relevant for those that are looking to just get started, understand the basics, nuts and bolts. And so please, if you want to get a copy of this book, take action and schedule a consultation, an advisor session, we call it, with one of my non-attorney advisors to see if patenting is right for you. So thanks, everybody. Have a great day. Take care. Go big, go bold.